many of the trade laws do not require that there be jurisdiction over the person committing the violation. The trade law applies to the goods
To the
coming
transaction.
to the transaction and to the goods coming across the border
Yeah.
rather than to the individuals committing the harm. So the idea is that many times in litigation, not just under the ATS, but under other statutes as well, personal jurisdiction is a very tricky kind of an
Yeah.
issue. And so trade law is a way to kind of deal with the problem. Sometimes it's a blunt instrument, it's a promising instrument, and it can often get companies to examine their supply chains much more carefully and much more thoroughly and much more proactively so that we can make some real progress on these human rights issues.
Human trafficking doesn't always take the form we first imagine. It can be found at almost any level of an organization's supply chain. What can compliance professionals do to assess human trafficking risk, and how can they leverage the resources of the organizations they work for to help root out this tragic problem? Gwen Hassan is here to help. This is Hidden Traffic.
Hello, and welcome to another episode of Hidden Traffic. I am your host, Gwen Hassan, and I'm very excited to have Dean Pinkert with me today. Dean is a consultant for the Corporate Accountability Lab, which is based in Chicago, although Dean, I think, is based out of Texas. So welcome, Dean. Thanks for joining us today.
Thank you. It's a pleasure to be here with you, Gwen. Actually, I'm located in Alexandria, Virginia.
Oh, you're in Virginia. Okay.
But it is remote work situation, and I really appreciate being on the podcast and talking through some of these really timely issues with you.
Thank you. So let's jump right in. First of all, tell us a bit about you and your background and how you kind of came to work in this human rights, human trafficking prevention sort of space. Where did you come from?
I come from Chicago originally, which makes it interesting that I'm working with a Chicago-based nonprofit. But actually, my career journey began as a labor lawyer in Austin, Texas. That's where you got the
That's
Texas
where the Texas was
connection.
from. Okay.
I had gone to law school at the University of Texas at Austin, Hook'em Horns,
Hook'em Horns,
and
yeah.
and then I obtained a position as a labor lawyer with a small Austin law firm. And I did that for about 5 years. I represented the Texas State Teachers Association and then later the Texas Federation of Teachers. I represented the communications workers and other labor organizations, did a lot of arbitrations, did some court cases. In any event, in 1989, I decided that I really wanted to do something more international. And sort of falling back on the tried and true technique, I thought, well, I'll get a master's degree in international law, and that will enable me to make a career switch into something a little more trade oriented, a little more international oriented. So I went to London, and by the way, London School of Economics international law programming is tremendous. And actually, they have a cooperative arrangement with the other universities that are part of the University of London so that you can study at any one of the schools there. And after 1 year, I got the degree in international law with a focus on international trade and decided to come to Washington, D.C. instead of going back to Texas. So I came to D.C. and pounded the pavement for several months. It was kind of an interesting situation because I had an office that was being lent to me during that time. So I had a place to go in the morning, which, by the way, I recommend to anybody who's looking
Who's job
for a
searching?
position.
Yeah.
But I found a position at the Commerce Department doing anti-dumping and countervailing duty cases. Did that for about 8 years. And then in 1998, I went into private practice. A couple of years later, I went to work for Senator Robert C. Byrd as his trade and judiciary counsel. And by the way, that was during a time when Senator Byrd was very much involved in the question of what happens to the anti-dumping duties after they get paid by the importer. He had this bill called the Byrd Amendment, which is pretty well known among the folks who've been doing the anti-dumping work for the past, let's say, 20 years. But in any event, did that for a while, and then I went back to the Commerce Department in 2002 for my second stint handling anti-dumping and countervailing duty matters. Although this time I got involved in a lot of stuff that I would not have been able to do the first time
The first time
around.
around. Okay. Yeah.
So I was involved in the softwood lumber negotiations that led to the 2006 softwood lumber agreement. I was involved in a bunch of WTO cases, including, ironically, the WTO case over the Byrd Amendment. And
Full circle moment, right? Yeah.
yes, and then also some WTO cases having to do with privatization of the European steel industry. So in 2007, with Senator Byrd's assistance, I became a commissioner at the International Trade Commission, where I served for 10 years. 2 of those years, I was designated by President Obama as the vice chairman of the commission, but the initial appointment came from George W. Bush. So I
Okay.
had both political parties there as part of my experience at the commission. After serving there for 10 years, I went back into private practice. And my second experience doing trade law in private practice was quite different than the
Mm,
first time. The first time it was mostly representing petitioners, U.S. domestic companies who were concerned about imports.
yeah.
Second time, it was mostly representing
Foreign
either
companies.
importers or
Yeah.
foreign entities. So it was quite different. But during that time, to answer your question, I got to know some folks through my colleagues at the law firm. I got to know some folks in the NGO sector, and in particular, having to do with human rights. I got to know some people at Mighty Earth, which was focused more on environmental issues. But then Mighty Earth and Corporate Accountability Lab, or CAL, were working together on some issues related to forced labor and child labor in the West African cocoa supply chain. So these are farms in West Africa that are ultimately supplying to chocolate producers. And so we were exploring various ideas about how to address the child labor and the forced labor issues in that supply chain. That led in 2018 to my attendance as a private practice lawyer, but my attendance at a hackathon that was conducted at the Harvard Human Rights Clinic by the
Mm.
Corporate Accountability Lab. That really kind of hooked me. I gave a presentation about all the various ways that the International Trade Commission could be useful in that area. And I got a lot of feedback, both constructive feedback and encouraging feedback about the things that we were talking about. And so eventually in 2021, I had the idea that I should just go to work full time with Corporate Accountability Lab. So the discussions proceeded over a few months. And in November of 2021, I joined Cal as special advisor, which, as the name implies, means that I could be advising them about just about anything.
I love when people share their kind of career journeys on the podcast because when I speak, I teach as an adjunct, and when I teach to new law students, 1Ls, 2Ls, they have especially younger ones, tend to have a very kind of linear view of what their career will look like. You know, I take this job and then I'm promoted to this job and then I'm promoted to this job. And in reality, most people's, including mine, have a job or career history that's much more multi-layer and matrixed and swing setty, right? It's jungle Jimmy. Sometimes there's a side swing. Sometimes there's a leap to the other side. Sometimes there's a move up, but sometimes there's a switch in philosophy. So I love that your career has really led you in kind of a full circle sort of a pattern of both sides of the aisle, both sides of issues, you know, international clients versus domestic clients, you know, government versus private. What a fascinating career you've created for yourself.
Well, thank you. 2 observations about this. One is that I totally agree that you never really know where things are going until they've gone there, and then you can tell a story about how it all came together. And the other is that younger lawyers and younger professionals should really keep their eyes and ears open and recognize too that sometimes the limitations of their current position will not be overcome by staying in that
Yeah,
current
yeah,
position, and they can find sort of a different path to get to their goals.
to get to what they want. All right, so let's pivot then back to kind of the corporate accountability line. Tell us a little bit about what it is. I mean, I know you've said that they do work with NGOs. You described the hackathon, which sounds amazing, but what is their kind of core purpose and model? How do they work?
So Cal is a small group, mostly lawyers, not entirely lawyers, but it's a small group, maybe 6 or 7 people in Chicago, and then one in Portland, and I'm in Alexandria, Virginia. And the idea is to incubate ideas for approaching human rights and environmental abuse
Mm,
issues that can ultimately give us some path forward in those areas. So let me give you just sort of a little bit of the origin story of
yeah,
Cal.
that would be great.
Cal was formed in 2017, not long before that hackathon that I mentioned, and it was formed by a couple of lawyers who were concerned that the Alien Tort Statute, which is a statute under US law that enables individuals and other plaintiffs to file cases that are premised on a violation of international law. It goes back into the late 1700s when it was passed, but the modern story of the ATS really begins in the late 20th century. I'm going to say in the 1980s, when litigants were able to file cases that were based on international law violations, and they were able to get judgments or settlements at that time. But what happened subsequently is that the Supreme Court and the other federal courts kept narrowing the ability to get relief under the ATS.
Under
A lot of it had to do with the fact that the ATS, even though it was originally intended to apply extraterritorially to events and happenings in other places in the world, the courts found that the extraterritorial application was in violation of a general presumption under US law. And so they just kept narrowing it. And the folks who formed Cal thought we need to come up with other ways of dealing with human rights violations, which can, as the name suggests, be in violation of international law. And I will say this, one of the cool things about trade law that makes it a very promising avenue for doing exactly what it is that Cal was trying to do when it was formed in 2017 is many of the trade laws do not require that there be jurisdiction over the person committing the violation. The trade law applies to the goods
to the
coming
transaction.
to the transaction and to the goods coming across the border
Yeah.
rather than to the individuals committing the harm. So the idea is that many times in litigation, not just under the ATS, but under other statutes as well, personal jurisdiction is a very tricky kind of an
Yeah.
issue. And so trade law is a way to kind of deal with the problem. Sometimes it's a blunt instrument, it's a promising instrument, and it can often get companies to examine their supply chains much more carefully and much more thoroughly and much more proactively so that we can make some real progress on these human rights issues.
I mean, that's just such a natural segue into the Uyghur Forced Labor Prevention Act, because you think about use of trade law, to fight a human rights issue. And I mean, that's the prime example, right? To your point, there's no need for jurisdiction over the trafficker that is, moving somebody into a factory in, some province somewhere. It's just stopping the goods before they enter the United States. And now, of course, we have the European version of that that's been proposed as well, beyond just Uyghurs, but, in a broad sense, any human trafficking produced goods. What is your view on kind of, to your point, the blunt instrument of a broad sweeping withhold release order that turns into a specific prevention of import of goods? I think often of the parallels between the Uyghur Forced Labor Prevention Act and conflict minerals, because I feel like the two of them have similarities in that, when we had Sarbanes-Oxley come out, the big push was, oh, we need to stop all of the horrible treatment of especially children in these mines in the Democratic Republic of Congo. So we're going to require all companies to start tracking all of their supply chains back to the ground and making sure that it was pulled out by, adults and by, well compensated people that have not been forced or trafficked. What we now know has happened, though, of course, is that you can now buy a barcode in the black market in the Democratic Republic of Congo that gives you a clean supply chain for your goods, and they're still mined by children, and or they've moved to new types of income streams that relate to, in many cases, drugs or to arms or to, it's a blunt instrument, to your point. It's an effort, but I don't know that it's solving the problem. Talk a bit about your thoughts about that. What do you feel kind of are the limitations of a trade approach, or the benefits for that matter?
Let's start with the UFLPA, the Uyghur Forced Labor Prevention Act, because I think it really is a watershed kind of a moment in trade law history. Of course, it's been in effect now for close to 2 years.
2 years.
And it's unique, well, not completely unique, but it's somewhat unique in that it applies a presumption to the import coming from a certain region of China, the Xinjiang Uyghur Autonomous Region,
Yep.
or to goods that are coming from companies that are on the entities list that is prepared by the Forced Labor Enforcement Task Force, which is an interagency group. And I think it's fair to say, I've heard it said by a number of researchers, and it seems reasonable to me, that when you have a situation of state-imposed forced labor, as we do in the Xinjiang region, we face a dilemma between slight over-enforcement, this is the blunt instrument, versus complete non-enforcement on the other side, right? So if you don't have a rebuttable presumption, the chances that you're going to be able to make a case with respect to Uyghur forced labor, which is a state policy in China, it doesn't work. And so I think that companies that are faced with a situation where they do the research into their supply chains and they can't really answer the ultimate question, like, am I in compliance with the UFLPA or not?
Yeah. Do I know where these goods are coming from, or do I not? Yeah.
Right. And so they do the research, they make the effort, and they still can't figure out what's going on exactly. I think in a situation like that, the company ought to apply what we called at the Commerce Department an adverse inference, meaning that if you can't answer the question, odds are
you should assume that there's a reason why you can't answer. Yeah, okay.
Exactly.
All right.
So, because we have small and medium-sized companies in many cases that find it very difficult to answer these questions. And so they have to make some assumptions about what's happening, and they will ultimately be held to account by the US government for the answers that they give. I'll say a couple of other things which I think you've been involved in and I think could be helpful to companies. First of all, there are technologies being developed that will help them to answer these questions about where the goods are coming from. It's not just cotton fibers, although it is cotton fibers, but it's not just. And there are technologies that can locate the plot of land where the raw materials come from. And that could be very, very useful. Another thing that is also useful is machine learning on supply chain links. And I've been involved in an organization called Supply Trace, where I'm on the advisory board. It's out of Northeastern University. It's a public-facing machine learning platform where a lot of data is processed. Much of that data is not available to the public without a fee, not by Supply Trace, but I'm saying if you tried to get the data commercially, you would find that there would be a fee. But if you go to the platform, it's kind of anonymized and it's made available to the public without a fee. So it's anonymized because the machine learning is used to trace out those supply chains. And so I think that can be useful as well. But I don't want to suggest that companies don't face challenges in this area. And look, we've just recently seen some action in litigation against the Forced Labor Enforcement Task Force, which is the 9-star litigation. And the judge said, on a preliminary motion that ordinarily he would require that more information had been given to the importer about the listing on the entities
On the
list.
list, right.
And so, there's a need for adjustment of policies to make sure that the companies know why they're being put on the list, but not breaching classified information or intelligence information that might be driving decisions by the US government. And we need to keep fine tuning these tools because the goal ultimately, and I want to say this emphatically, the goal in most cases where you don't have the kind of situation that you have in Xinjiang region, but in most cases, it's not to stop the trade. It's to make sure that the trade is free of forced labor. In the case of Xinjiang, it's a little more complicated because with state-imposed forced labor, you don't have a lot of options once you find out that you're connected to that source.
That supply chain. Yeah. Well, and there's new data out around UFLPA seizures that the number that they're seeing, I don't know if seizure is actually the right term, stops, maybe withholding of release in Mexico and Canada for that matter, because importers are trying to find ways around a clear indication that there's a connection to that province. So they're shipping it to Mexico first and then importing it from Mexico so it looks like a Mexican import. But obviously, Customs has the same type of technology and they are already on top of it and have seized a huge number of potential imports that have connections to that supply chain coming in through other places like Canada and Mexico. So I think to your point, the real takeaway here is that I loved your phrase that if you can't figure it out, you have to make a presumption that maybe there's a reason why you can't, and that it's better to make those changes to your supply chain than to end up with goods being withheld, either here or now with the EU CSRD and CSR triple D coming out in Europe, the due diligence directive. It's going to be, not just a US issue, but, a European issue as well.
I do want to mention 3 areas where I think that the US government needs to adapt and find ways to combat some of the things that are happening, not just with respect to the UFLPA, but also with respect to forced labor in general, which could be any country. But the 3 things are: 1, when a good is detained here in the US and then finds its way into other markets. So it gets re-exported to other markets. And one of the ways that that needs to be dealt with is to get other countries to adopt effective regulation, and also for the US government to share information with other governments so that everybody is more or less operating with the same information. Again, there can be technical problems with classified information and
Sure.
proprietary information, but in general, I think sharing information is one of the ways that we deal with that. Second kind of circumvention, which you mentioned, but I want to actually flesh it out a little more, is this idea of shipping through a third country into the United States. And one of the things that can happen with that kind of a technique is that there could be a manufacturing process that is occurring in that third country. A little bit of finishing or a little bit of rejiggering or retooling
assembly of some kind, or
assembly. And so then customs faces the question of, first of all,
what's the country of origin here?
What's the country of origin? And also, is there forced labor in the production of that product in whole or in part, which is what the statute says under Section 307. So I think that can be very tricky. And you can have a situation where, in fact, the country of origin is the third country because of the remanufacturing, and
Right.
customs could still find that there's a portion of that product that was tainted by forced labor. So I just want to put that one out there for all of the folks who maybe are involved in the technical elements of that. That could be an issue. And then the third thing is something that is just beginning to emerge, which is the bifurcation of supply chains, where let's say that we have a UFLPA situation and the Chinese company will have some manufacturing outside of the Xinjiang region and some manufacturing inside. And so what they do is they rejigger their supply chain so that the Xinjiang origin stuff is not coming to the United States, and the stuff that's being produced elsewhere in China is coming into the United States.
US.
And while
Okay.
that's not technically illegal, it does defeat the purpose of the UFLPA, which ultimately is to try to address the underlying conditions. So that's something that the US government needs to look into, our trading partners need to look into, and actually, if other countries adopt strong preventative measures, then the incentive to do that would go down.
Yes. Fascinating. I didn't know that that bifurcation was happening, but my first thought when you said that was it sounds like kind of a manufacturing equivalent of money laundering, right? but it's origin laundering. We're going to give you a clean part of our supply chain for you people, but the rest of the world gets the other part. Interesting. All right. Well, we have been chatting away and we're at time now. So thank you so much for your insight. I found this, a fascinating conversation. How can people get more information if they would like to reach you or learn more about the Corporate Accountability Lab?
So CAL, Corporate Accountability Lab, has a website at corpaccountabilitylab.org. I have an email address, dean@corpaccountabilitylab.org, and I'm happy to answer questions. I do want to say just a couple of things in closing, which is the most important thing for companies to be thinking about here, as we've talked about, is the full tracing of their supply chains back to the raw material level. And then, of course, apply inferences where appropriate, as we've talked about. Consider the technologies that are available and the machine learning that's available. And finally, one point that just goes to our recent report on the Indian shrimp industry at Cal, and that is that labor and environmental abuses often go together. So if you find that there is the one kind of abuse in your supply chain, you might look for the other as well.
That's such a good point because it also relates then to bribery and corruption, which I personally think you can't have one without the other either, right? You're never going to go to a source and find that there's forced labor or human trafficking or illegal child labor where there isn't also some form of graft or bribery or corruption or kickbacks going on to keep that process running. So the bad actor kind of at the end of the day is the bad actor in many areas. And you should look for the environmental concerns. You should look for bribery. You should look for human trafficking altogether. Great point.
100%.
Yeah.
And if you find something, say something. This is not the kind of thing that it would benefit companies to go slow on. Report it, deal with it, and if you have to disclose it to the US government as well, go ahead and do that rather than face long-term penalties and the kind of investigatory, let's say, tools that might be employed by the US government.
By the US government. Yes, that's a gentle way of putting it, Dean. I like that. Well, thank you very much for your time. It's been great talking to you.
Great talking to you. I really appreciate it and happy to do it again.
Thank you.